Good day, I am Jake Rañada from BSHM 3A, and for this time I will be tackle the chapter 4, and we will discuss about law on partnership and corporations. In a high-level industry like the tourism sector, it is imperative that it strictly complies with the legal requirements in order to operate as a legitimate business. Startup operations must have a strong foundation, and in order to have a strong foundation, you must start with a strong business organization. Forming a partnership or a corporation is a better choice in a forming business organization in order to enter a competitive industry, like the tourism industry. This chapter will present an overview of a partnership and a corporation as a business organization. The law on partnership is governed by the Civil Code of the Philippines, while the law of corporation is governed by the Batas Pambansa 68 Corporation Code of the Philippines. Law on partnership. In Article number 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund, with the intention of dividing the profits among themselves. A partnership is an association of two or more persons to carry on as a co-owners of a business for profit. The definition of a partnership does not include religious associations, conjugal partnerships, and other of a similar nature because a partnership as defined by law refers only to associations the purpose of which is to obtain profits to be distributed among the partners. A partnership contract is based on trust and confidence. Hence, the fiduciary relation in a partnership stems from the principles of delectus persona, wherein no one can become a partner in a partnership without the consent of all the partners. The essential requisites of a partnership are: first, an agreement to contribute money, property, industry to a common fund. This is complied with if each one of the partners brings or obliged to bring something to the partnership, and that which is brought becomes common property. Second, intend to divide the profits among themselves. This is complied with if first, partnership is established to obtain profits. Second, profits must be common to all parties. And lastly, profit or loss must be divided among the partners. Advantages and disadvantages of forming a partnership. First, the advantages, which is easy to form, improve growth possibilities, and lastly, freedom from bureaucracy. Disadvantages of forming a partnership. First, instability. Second, difficulty in obtaining large sums of capital. Third, firm is tied to the acts and judgment of one partner as agent. And lastly, difficulty in severing partnership ties. Classification of partnerships. First, according to subject matter, there are two types of partnership of this. First is the universal partnership, a partnership where all of the partners contribute all of their properties to the common fund and speaks of no particular purpose or subject matter, as long as the purpose in forming a partnership is to obtain profits and it's not contrary to law, morals, public order, and public policy. Nowadays, seldom if none do you experience business establishments forming a universal partnership. Second type of this partnership is the particular partnership. A particular partnership has for its object to determine things, their use of fruits, or a specific undertaking, or the exercise of a profession or vocation. Next type of classification of partnership is the according to liability. There are two types of this, which is first, the general partnership, composed of general partners where liabilities extend to their personal properties. Next, the limited partnership usually attaches the word Ltd or limited at the end of the company name. One formed by two or more persons having as members one or more general partners and one or more limited partners, where the liability of the latter to the third person is limited to their capital contribution. And the last classification of partnership is according to duration, which is the partnership of a firm fix, is one in which the term of its existence has been agreed upon expressly or as when there is a definite period, or impliedly as when a partic- particular enterprise or transaction is undertaken. The expiration of the term thus fixed or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. Forms of a partnership. A partnership can be in any form, even if not recorded at the Office of the Securities and Exchange Commission, except first, when it is stipulated, second, when immovable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory of the immovable properties and signed by the parties, otherwise the partnership is void. And lastly, in case of limited partnership, the parties must sign and swear to a certificate which shall state, among others, the name of the partnership adding to the word limited and the character of the business. File for record the certificate in the Office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirements will only make the partnership a general partnership. The succeeding pages show a sample each of the article of partnership for both a general partnership and a limited partnership. Law on Corporation. In Section 2, Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. In the Philippines, the law which governs the creation of private corporation is Batas Pambansa Building 68, known as the Corporation Code of the Philippines. Right of succession means that a corporation has the capacity to exist regardless of the death, withdrawal, insolvency, or incapacity of the individual stockholders and regardless of the transfer of interest or shares of stock. The powers of all corporations are limited to those mentioned in their charters or in the general acts under which they are created. Kinds of corporation. First, stock corporation, one of which has a capital stock divided into shares and is authorized to its distribute to other holders of such shares dividends or allotments of the surplus profits on the basis of the shares held. A stock corporation is organized for profit. The governing body of a stock corporation is usually the board of directors. Second, non-stock corporation. One where no part of its income is distributable as dividends to its members, trustees, or officers, subject to the provisions of the Code of Dissolution. A non-stock corporation is one not organized for profit. The governing body is usually the Board of Trustees. Third, corporation de jure. A corporation organized in accordance with the requirements of law. Fourth, de facto corporation. A corporation where there exists a flaw in the corporation. Fifth, public corporation. One formed or organized for the government of a portion of the state. It is created by its own charter for the exercise of a public function. Examples: barangay, city, or municipality. Sixth, private corporation. One formed for some private purpose, aim, or end. It is created by incorporation under the General Corporation Law. This includes a government-owned and controlled corporation with an original charter and quasi-public corporation. A private corporation performing public functions. Corporation sole one organized for the purpose of administering and managing as trustees the affairs, property, and temporalities of any religious denomination, section, or church. In this corporation, there is only one incorporator. And lastly, eleemosynary corporation, one organized for a charitable purpose. Advantages and disadvantages of corporation organization. First, we will discuss the advantages. There are six. First, strong separate juridical personality. Second, limited liability to investors. Third, free transferability of units of ownerships. Fourth, centralized management through the board of directors. Fifth, professionalism. And lastly, easier to sell small amounts of stock to raise capital. And disadvantages of corporation organization. First, extensive government regulation. Second, double taxation. And lastly, activities are limited by charter and various laws. And that ends with the discussion. Thank you for watching.